How do you detect a fraudulent will in an estate? Imagine opening a will that suddenly changes everything you thought you knew about your loved one's wishes. How can you be sure it's real? Detecting a fraudulent will is a process that involves careful observation and investigation. First, look for signs that the will might not be genuine. Check if the signature matches the testator's known signatures from checks, letters, or previous wills. Look for shaky strokes, cut-and-paste signatures, or inconsistent handwriting. Notice if the will's provisions are drastically different from earlier valid wills, or if it benefits unknown individuals or excludes close family members unexpectedly. Be alert if the will appears after the testator's death with no prior notice, especially if earlier wills have disappeared. Examine the witnesses' signatures. If they seem uncooperative, unidentifiable, or forged, that's a red flag. Also, verify if the will was properly signed and witnessed according to the legal formalities. Missing signatures or lack of notarization can be suspicious. Pay attention to the paper, ink, and formatting. If they don't match other documents signed by the testator, that could indicate tampering. Signs of undue influence or mental incapacity at the time of signing, like isolation or coercion, are also important clues. Next, gather evidence by comparing known handwriting samples to the signature on the will. Interview witnesses, including notaries or friends present during signing, to confirm the circumstances. Review medical records or caregiver statements to assess the testator's mental state. Look for physical signs of alteration, such as erasures or different inks. Trace when the will was created and filed. Suspicious timing or missing earlier wills can suggest fraud. Consider any strained relationships or conflicts that might have motivated someone to forge or manipulate the will. To go further, forensic document examiners can analyze handwriting, signatures, ink, and paper to verify authenticity. Experienced probate attorneys can evaluate whether the evidence supports claims of forgery or undue influence. Sometimes, digital records and metadata are examined if the will exists in electronic form. If the evidence points to fraud, the next step is to file a will contest in probate court. Present expert testimony, witness statements, and physical evidence to support your case. If the court finds the will is fraudulent, it will be declared invalid, and the estate will be distributed based on an earlier valid will or by law if no other will exists. Protecting vulnerable individuals from fraud is a key part of estate planning. Regularly updating documents and keeping them in safe, accessible places helps prevent fraud. Acting quickly when suspicions arise is essential to preserving the true wishes of the testator and ensuring the rightful heirs receive what's theirs. Detecting a fake will involve paying close attention to signatures, document details, and relationships. Using legal and forensic help can make all the difference in proving whether a will is real or fake.